Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In the last two classes, we have been dealing with the constitutional jurisprudence, concept of constitutional jurisprudence, in which judicial review is one of the most important aspects. The origin of judicial review, of course, it is there in our Article 13. Whichever laws are repugnant to the Constitution which are not inconsistent with the Constitution, definitely they will be declared as void. You know, doctrine of severability, doctrine of eclipse, all these things. In such cases, the court can exercise the option of judicial review, and Supreme Court can review its own judgments also. That is another advantage. This concept of judicial review has emanated from a case, very famous case, the first case of judicial review in USA, that is Madison versus Marbury, or we can call it as William Marbury versus Madison, 1803. The first case, where the Chief Justice Marshall, Thurgood Marshall, he has declared that when the law is inconsistent with the Constitution, definitely the judiciary has got power to say like that. They can actively give some judgment in this connection. This is what is judicial review. If you go to the facts of the case, this happened in the year 1803. 1800, there were elections. Mr. John Adams, the Federalist group, he was not successful, and he was defeated by Thomas Jefferson. And before demitting the office, John Adams successfully appointed 42 persons as the justices of peace, or we can call them as judges. 42 persons. And the Senate agreed, the Senate signed, and they were sealed. That means the warrant of authority was given. And somehow the Secretary of State, that is Foreign Minister, Home Minister, before the handing over the power to Thomas Jefferson, he has given the orders to some of them, but he could not serve the so-called orders to 17 of them. And William Marbury is one such. See, William Marbury was appointed at the time of John Adams, but he has to take charge in the time of James. What is this man? I remember, suddenly I am getting confused. So, Thomas Jefferson, yes. Jefferson instructed his Secretary of State, that is John Marshall, not to deliver the orders, because they are not our people. They were selected or they were appointed by my predecessor. That too, not our party, other party. Why should you? That is his intention. John Marshall, so the Secretary of State, did not give the so-called warrant of authority or the so-called appointment letter to William Marbury. Then he is a judge, he is an advocate. He approached the Honorable Supreme Court of America for issuing a writ of mandamus. A writ of mandamus under Section 31 of the Judiciary Act of 1789 of America. He filed a petition in the Supreme Court, for issuing the writ of mandamus. Here, the Chief Justice Marshall was actually in a dilemma position, because number one, who has to give the orders of appointment? The government. It is for the prerogative of the government whether to issue the orders or not. But here the point is, the orders were already issued. Only implementation is the problem. Now, no doubt, according to Section 13 of the Judiciary Act, the Supreme Court original jurisdiction is limited to the cases relating to the ambassadors, other public ministers and consuls, and those to which state is a party. That's all, not the judiciary. Now what to do? Balance of convenience. You see, judicial review, because now the court cannot keep quiet or sit tight saying that it is for the government. If they are pleased, take the orders. If they are not pleased, we cannot do anything. Not that. They did not say like that. When a warrant is issued, that means when appointment is made, yes, it is the prerogative, it is the duty of the state to respect the same. Come on, post him. This is the order given by Chief Justice Marshall. So he has given the judgment. So please remember, it is emphatically the duty and province of the judicial department to uphold the legal position. So very good case law. So please read the case law and enrich your legal knowledge. Yesterday I have discussed that, but you people did not remember the case. So this is Madison, once again I am confused. Marbury versus Madison. Marbury was the judge appointed. James Madison was the Secretary of State, or just like our Home Minister. Right? Please read the case law. Very good case law on judicial review. So we have discussed our own case laws in the test of reasonability. Oman Rao, V.G. Rao. So State of Madras versus V.G. Rao, 1952. That People's Education Society case law. Okay, we'll discuss it some other time. For the present, I am staying back. Thank you very much.